the way that injured workers were treated.
It's not just about compensation anymore. It's about fighting for what's right.
They went and got me answers. They will work very hard to resolve any issue that comes up in your case.
This is about going above and beyond. We won't stop until the job gets done. That's who we are.
Hello, everybody. Welcome to the ultimate webinar for workers' comp. We're very excited to have you guys all on board today on this workers' comp webinar that we host once a month. My name is Carmen, your host of Work Comp Talk podcast, which I'm not going to toot my own horn, but you know what? Maybe I just will. We are one of Northern California's biggest workers' comp podcasts. So if you haven't had a chance to go on your favorite podcast app and check out Work Comp Talk, hint, hint, you might find some great insights, secrets, and stories within that podcast as well. Bilal, thank you for joining me. We have a lot of information going on today. I'm going to give you the mic in just a little bit. I'm going to allow people to keep joining us as we are just starting this webinar. So if you are watching us from the link on the email that was sent to you because you registered, thank you for joining us. Thank you for following us. And if you're joining us through YouTube Live, welcome. Don't forget to hit that subscribe button so you get notified every time we upload new content to our channel. So there's a lot of information that's going to be shared today, and I hope that you guys take it all in and that it does allow you guys to truly understand the system, because our ultimate goal for this webinar is to allow injured workers to understand their rights, to get a little bit more information from their case in regards to what you are entitled to, and most importantly, to give you the opportunity to join a live Q&A session where Bilal Kassem is going to be answering some of those most itching questions you guys might have. So without further ado, let's move on with our webinar this morning. So who is this webinar for? This webinar is for injured workers who have been hurt on the job, of course, someone who not only has been injured on the job, but could also obtain an illness through your work. It's also for people who are unsure about what benefits you're actually entitled to when it comes to your workers' compensation rights. I feel like most people get injured at work and don't necessarily know or study anything about it beforehand. It's almost like it's a tool that you don't need or you don't know about until you're actually in dire need of it or when you're injured at work. So this webinar is for all injured workers in the state of California, those that are feeling frustrated and overwhelmed, because believe it or not, the system can break you. The system can overwhelm you. It can frustrate you. There's just so much information to the system that it's not a surprise that you're not expected to know everything. It's like any other job. People do this for a living. We dedicate ourselves, and when I say we, injured workers dedicate themselves to their career. We're not expecting everyone to know everything. So this is the webinar for you to try to get as much information as you can from those that do this for a living. It's also for injured workers who are just ready to take control of their claim. They're tired of the excuses. They're tired of the back and forth communication with the claims adjusters who maybe doesn't listen or just, is always MIA. It's hard for you to get a hold of. It's really difficult for you to even get a word out there. This webinar is for you. So what are we going to learn in this next webinar? There's a lot of things that we are going to be talking about, but I want to introduce to you who is going to be guiding us on all of the information that we're going to be diving for the next 50 minutes. It could be less. And I want to introduce to you none other than Bilal Kassem, who happens to be the co-founder of Pacific Workers, the Lawyers for Injured Workers. It's Northern California's top workers' comp law firm. Bilal brings an extensive experience in workers' compensation law. He has helped thousands of injured workers be able to navigate the system in a way that benefits them in their best possible way. Not only that, he's been able to take $350 million away from the insurance companies and put those back into the pockets of injured workers. He is here to strive and to empower you as an injured worker and let you know on your rights. Bilal, thank you for joining me. How are you?
I'm doing fantastic. Always happy to be here to help.
We're excited to have you on board. I love having you on these webinars. We do them once a month, and there's a lot of great questions that come into play at the end of the webinar. There's a lot of information that we share for those that are new to the system, but most importantly, we get to pick your brain. We get to pick the brain of someone who chose this as a career. So tell me a little bit about yourself, Bilal. How many years have you been doing this for? And yeah, just break it down to why should I trust the things that you are going to share with us in this live webinar?
Yeah, so I guess I don't need to start from the very beginning of my lifestyle, but certainly, at least since I went to law school, I graduated law school in 2011, immediately passed the bar first time around, and started practicing labor and employment law. I used to represent mainly employers against wage and hour class actions, discrimination, retaliation, termination cases. And from there, I got poached by insurance companies to work in big firms doing insurance defense with crossovers into workers' compensation. That ultimately was pretty short-lived considering the nature of the work. A big win for the insurance company means an injured worker gets nothing. And,
Damn.
at the end of the day, being counting my hours that I billed to the clients and, preventing injured workers from getting benefits wasn't really a sustainable practice for me as a lifetime career. And so, I left that field pretty quickly to start an applicant-oriented business, which is representing injured workers, which now I've done since 2014 to the present. Help nothing but injured workers throughout the state of California with their claims and workers' compensation. So I've dedicated essentially my whole life career now at this point to helping people in need.
We're excited that you switched sides, but I'm not mad at the idea that you started helping out the insurance companies first, because I think that was a really good eye-opener for you to understand some of the ways and tricks that they used and that they taught you as an employee to navigate, and you were able to use that and bring it to benefit the injured worker. Can you tell us a little bit of what are the things that you saw when you were representing the the insurance companies and not the injured?
Yeah, we call them true believers, right? The number of true believers on the insurance side of things is astonishing. These are really people who believe in the insurance business. They believe that, profit over people. They believe at the very core that a lot of workers' compensation cases are fraudulent, that people are only in it for the money, that they're looking for paid vacations. And really, the idea is to save as much money as possible to make the insurance company profitable. And that echoes throughout the business, which also is the core of what defense work is really all about, is how do we defeat claims? How do we reduce exposure? How do we limit the cost of administering these cases so that the insurance company can keep as much money as possible in their pocket? The perspective that you see on TV with, the insurance adjuster showing it someone's burning down house at 3 a.m. and hugging them and putting a blanket over them and saying they're always going to be there and stuff. It's a fantasy. And my experience has showed me that it's really the opposite. And there's been a few cases that were really memorable for me as a defense attorney, which kind of pushed me over the ledge and got me out of the business. So, I really saw that at heart, and, quite frankly, it's pretty evil.
Yeah. I can totally see that being a tactic that is being used, because when you compare workers' comp with, say, anyone's regular car insurance, at the end of the day, insurances are for profit only. They're not necessarily here to make your life easier. They're just here to take care of their situation, their stakeholders. They're there when you need them, but they're going to be there the least amount of time possible. So let's get diving into some of the secrets that we're going to be sharing today. So I hope that you guys join us for the next 45 minutes and truly take notes, truly take into consideration some of the things that we're going to be sharing with you. I do also want to give you guys a heads up. At the end of the webinar, there is an opportunity for you to ask questions. So go ahead and hit those chats, start asking those questions so we can start getting those ready for you as well. And if you just so happen to have to walk away from this webinar, don't worry about it, because you'll be able to watch the replay free no cost on YouTube, on our YouTube channel. Just search us up as Pacific Workers. If you did register through the entire flow of our webinar, then you will be getting replay videos as well. We won't be mad if you walk away, but make sure you come back so you don't miss the rest of the information. We hope you can stick around. We're going to try to make it as fast as possible, as short as possible, but with the most important information that we need to share regarding the workers' comp. So let's start with the basics. Bilal, there's a lot of people that are new to the system. They've just recently obtained an injury. They don't even know what workers' comp is. So can we explain to them and to everyone joining us on this webinar once again, what is the purpose of workers' comp?
Workers' compensation, in terms of the legal world, is somewhat new. There was things we had back in the day originally in the courts in England where, common law was practiced and stuff where, you had personal injury. The technical term for it is called torts, right? Assault and battery, typical negligence cases, things where accidents happen and you can sue someone for it. That law was brought over to the United States, obviously, being that, that's where we came from originally. And at least in our current setup. And yeah. The whole idea was that anytime someone got hurt at work, they could sue their employer if the injury was caused by negligence. Now, as a risk profile, that's not really great because employers can't necessarily stomach the cost of litigation. If every time someone got hurt in a high-risk business, employers for the most part would be bankrupt. There's a lot of stupid stuff that happens at work, whether or not it's right or wrong, it happens. And so workers' comp way back when was created as a carve-out. There was this deal called the Grand Bargain or something like that, is back in the 1800s, where essentially injured workers traded their right to sue their employers for negligence in court in exchange for workers' comp, which is supposed to be a benefits delivery system. And so the trade-off was, hey, injured worker, you can't get basically a full judgment, damages and loss consortium and all these things that you get in a negligence case. But you also don't have to prove fault on the employer's behalf anymore, which means that it's easier for you to administer or get your benefits than it would be otherwise proving a negligence case. And so the system was created as a benefits delivery system. The whole idea was supposed to get injured workers medical care and financial stability while they're off recovering from their injury, and then ultimately compensated for the long-term results of their injury by way of permanent disability. And so really there's two buckets. It's medical and it's money. And those things are supposed to be delivered to you as an injured worker fairly frictionless. It's not always the case, but really it's become a very litigious business and there's a lot of fighting that goes on in these cases. But the whole idea is, look, you got injured, you're in need of medical care, you're in need of benefits. These are things that are supposed to be given you without having to prove, negligence or fault on the part of your employer. And it's supposed to be done quickly so that you don't have to suffer and sit on the sidelines.
Correct. Okay. So workers' comp, it's supposed to ensure that the workers receive the appropriate medical care, the medical treatment, the benefit sides of anything that needs to happen in regards to you recovering from whatever injury or illness you obtain at work. And it's also supposed to help with compensation, meaning while you're out sick, while you're out recovering, you still need to make some sort of money to help, with your everyday life, with those bills, with those lost wages that you're not making because you're not actually at work. So it was supposed to be for all of that. And for the most part, would you say, Bilal, that workers' comp does do that? Is that, because I, not that long ago, read a statistic in California, 1 out of every 5 claims that come in through workers' comp are flat out denied. That's a huge percentage.
Yeah, workers' compensation has changed over the years. Certainly is financial incentivization on behalf of the insurance companies to save money has become the big thing, the idea of profits and generating corporate revenue and things like that. Obviously, there's a huge pressure on the legislature, for one, to change laws to make it less favorable to the injured worker. But then there's also the practice in actually getting the benefits and ensuring that the court system is working effectively to resolve disputes and ensure that things are happening quickly. So, there's a lot of pieces that are not necessarily directly related to each other that contribute to oftentimes there being substantial delays and problems for injured workers getting the benefits. And, more often than not, I would say there is some benefits delivery. There is some financial benefits, medical benefits that are delivered to the injured worker, not necessarily everything they want. and more. And so I think a lot of times injured workers do get disappointed with the outcome and the process of going through a workers' compensation case. And there are injured workers who are frequently denied.
Yeah, that sucks. Okay, so let's break it down in the sense of what the benefits are. I think it's very important to truly understand where these buckets fall, right? You mentioned financial, you mentioned the medical treatment, but it's also important to break each down to truly understand what is it like from beginning to end. How does this help someone determine the length of their case? Because obviously someone feels they get injured, they fall, they fill out their first form, but there are deadlines that need to be set into place. There are things that there's waiting periods that can essentially prolong your case. So let's talk about the medical treatment aspect. Let's stick with that bucket first in workers' comp. For medical treatment, can you define what this is? What is this entitled to for the injured worker?
When we talk about medical care and workers' comp, we're talking about anything that's necessary to relieve or cure their industrial issue. Of course, we have something in workers' compensation called utilization review, which is the insurance company basically getting to decide whether or not the things your doctor wants to do for you are medically necessary and appropriate. So, for example, your doctor wants to do a lumbar spine laminectomy or a total knee replacement, a fusion, they want to do radio frequency ablation, whatever the procedure is, they have to request authorization first, which
Right.
means, unlike maybe going to Kaiser, for example, where you see an orthopedist and they say, hey, go down to floor 2 and get an MRI, and they send you down there the same moment you get it done. Your doctor has to ask for permission first. And utilization review, which is a company that's paid for by the insurance company, which is an inherent conflict of interest, I think, has the right then to decide whether or not your treatment is approved or not. And
Which,
more often than not, treatment is denied. So, there's that battle. But, in a perfect world, everything your doctor wants to do should get authorized, and it should get authorized in a timely manner. But the reality is utilization review denies a lot. And the appeals process, which we have in workers' compensation, which is called IMR, is not much better.
gosh,
IMR is independent medical review, which is essentially state contracted doctors. We don't necessarily know their specialty, or education, or experience, who review the denials by the insurance company and decide whether or not the denial should be overturned or not. More often than not, just like utilization review, the IMR upholds the denials. I think last time I checked, it was like 88 or 92% or something really high of decisions to deny treatment to injured workers are upheld on appeal.
Wow, that is scary looking. Okay, so let me understand this. You go to your primary doctor or the doctor that let's say your boss sends you. You get injured at work, and then they'll tell you, hey, go to the work clinic. The work injury clinic doctor is your primary doctor. They're keeping an eye out on things, but they need certain things to be approved by the insurance. The insurance does not approve them. So then you appeal, or you were like, wait, but I really need this. So you have to like fight for your medical treatment, which the IMR, the independent medical review doctor, which is provided by the state, which we don't know what their specialty is, comes in and plays a significant role. Whether you are entitled to what the first doctor said, that is like bananas. That's mind blowing. But unfortunately, I can just imagine someone in pain having to wait for this. How long? What's the waiting period for all of this?
So utilization review should take no longer than 14 calendar days. If there are certain steps, usually it's 5 business days. The IMR process can take over a month. So, if you need, let's say the doctor wants to do a simple arthroscopic shoulder surgery. It's a simple procedure, but it would alleviate a lot of pain and problems for you. That process, if it's denied and you have to wait for IMR, you could have to wait for surgery for like 2 months, which if you're sitting there suffering in pain, that's forever. A lot of people don't have that long to wait,
Right.
And that's just if it gets overturned and you actually get the surgery. There's a lot of times the decisions don't overturn the utilization review decision, in which case a utilization review decision denying treatment stands for up to 12 months unless there's a change in circumstance. which means that your doctor can't simply re-request the same procedure and send it through utilization review. Again, maybe there's a change in circumstance that justifies it. For example, utilization review denied your doctor because they said you didn't have an MRI study done, and then you get the MRI study done. That would be a material change in circumstance. So your doctor could immediately re-request it.
Because there's like a new discovery, right? They saw something
Exactly.
now new.
It's material to the decision that denied it. So you'd be able to submit without waiting 12 months. But
now, when you say submit without waiting and all that stuff, there's a lot of people that don't hire an attorney, and they get, they kind of get the information on the mail, like the insurance company is supposed to provide you with the instructions on how to do it. And what are the odds of someone actually understanding what they're doing when they're trying to fight these denials?
I think some concepts in workers' comp are pretty easy to understand.
Okay.
Unfortunately, the issue with workers' comp is that there are tight timelines. There's deadlines for doing certain things. There's a deadline filing IMR, for example. So if you wait too long, or the information you need to appeal isn't provided to you on time, that obviously can impact your right to file the appeal. There's ways to challenge that, obviously dragging them to the court, saying they didn't fulfill their statutory duty to provide those things to you, so the timeline should be waived. You get a court order and things like that, which we have to deal with, regularly as a law firm. But those are things you may not know. The information you don't know is the information you don't know, so you don't know how to fix these things.
Right. So what is that deadline or that timeline that you just mentioned? Like, how long do you have to file an IMR?
It's 30 days. So, when we're looking at decisions to appeal, you have to act quickly. You can't wait, 45 days, 60 days, or maybe you don't even have the appeals paperwork or doesn't know it exists, which is pretty common.
Okay. What about, gosh, there's just so much deadlines and things that are, I feel like we're only scratching the surface, right? And there's just so much more that goes deeper into the webs and can easily confuse and trap people into loopholes that don't benefit or look out for their best interests. So you mentioned the deadline for the IMRs. Is there a deadline when people, for example, and this is common, people get injured at work but don't want to file a claim right away because they feel like, oh, I'll just wait it out. And then a week goes by. There's still aches and pains. There's still things that they're dealing with. What is the deadline for you to get on an injury and file it? Like, is there a deadline for that?
So you're supposed to fill out what's called a DWC-1 claim form within 24 hours of having your injury happen. DWC-1 claim form is the official form that's used to actually report the case to the insurance company and start the process. You fill out the top half, your employer fills out the bottom half, and off it goes to the insurance carrier, which then officially opens the claim.
Okay.
Now, the insurance company may get notice of the claim if you're not able to fill out the form. We've had clients who have gunshot wounds, they've been in car accidents, amputated legs, so they're airlifted to hospitals, things like that. They're not filling out forms, like it's impossible. And so the employer still has a responsibility to report the case to the insurance company. Now, when you're talking about filing a case in court, that's a different subject. And there is what we call a statute of limitations, which means you do have a definitive time to actually file an appeal to start a court case. And if you waive that timeline, you wait too long, it's gone. You can't file a case.
So you lose it all.
You lose it all.
Yikes. What is the deadline for that?
So it depends. That's about as lawyer as an answer I can give. But, you think of the 1 year statute of limitation. It's supposed to be 1 year from your date of injury or last date of benefit conferred, which means, if you're getting permanent disability or medical treatment that's being paid for by the workers' compensation insurance carrier, that does toll the statute of limitations, which extends it. If your case is denied, that obviously doesn't extend it. You have 1 year, so you got to file quickly.
Wow. Okay. So there's a lot of deadlines that could either make or break your case. They can prolong your case, and not every case is the exact same. It's not a one size fits all. From what I'm understanding, it's based on the circumstances that you are involved within your case, your injury, the doctors you're going to get, and who knows, there's probably a whole plethora of things. Let's talk about, we know now medical treatment provides the essential support for injured workers. And that means anything that is needed to take care of that injury or illness, right? What about the temporary disability, the part where the money comes in? Because that's also a very important thing. Are there any delays within the benefits of temporary disability? Like, please talk about this bucket of workers' comp.
So for the financial benefits in workers' comp, there's really two main benefits. There's temporary disability and permanent disability.
Okay.
Temporary disability is designed as a wage replacement. The idea is to help cover your lost wages while you're off and you're still improving and recovering from your injury. Whereas permanent disability is more of a benefit that's designed to compensate you for the functional limitations you have following an injury that couldn't be fixed with medical care, not necessarily your inability to work or changing career. So when we're talking about temporary disability, it's supposed to be paid to you biweekly. It's supposed to be 2/3 of your average weekly wage. We look at your average weekly wage, typically looking at the 52-week period preceding your date of injury. If there's less time, we use less time. It just depends on how long you're with your employer and how consistently you've worked. And there's minimums and there's maximums that are associated with temporary disability rates in California. Those rates change every year based on inflation data. So, the max temporary disability rate now is more than when it was 5 years ago, but it's still a max. So, there's some people who do hit the max rate, but the whole idea is that you're supposed to be paid temporary disability in most cases up to 104 weeks within 5 years from your date of injury. It doesn't need to be consistent. It can be broken periods if need be. But as long as a doctor says that you cannot work or that you have work restrictions that cannot be accommodated by your employer, then you're supposed to be receiving the benefit. A lot of times that doesn't happen, though. We have denied cases where temporary disability is not being provided to people. We have cases that are delayed, meaning the insurance company is still making a determination about whether they want to accept liability, in which case they do have to provide some medical care, but they don't have to pay the benefits. So, you have, there's an investigation period. Essentially, the insurance company can have up to 90 days after a case is reported to determine if they want to accept liability. And during that time frame, if it's delayed, they do not have to pay you temporary disability benefits. They may owe it to you on the back end, but what was that? I'm sorry.
How do you survive? How do you pay your bills? How do you buy food?
So, a lot of people burn through vacation time. They burn through sick time. Typically, we would advise people, if their case is denied, to apply for a state disability insurance through EDD, which is essentially your own little savings account with the state. If you look at your paychecks, there's a line item deduction for CASDI. Essentially, a state of California, you pay into the benefit, and then you can draw from that benefit.
Got it.
And EDD will typically look at the 4 quarters of earnings you have leading up to the effective date and determine what your pay rate is.
Okay. But you could do that when they're not paying you. You can't do that when workers' comp is giving you temporary disability and then try to also get EDD.
Double dip? No, you can't. You can't draw EDD and TTD at the same time. If there's a difference in rate, maybe, but that rarely ever happens. For the most part, you cannot draw both benefits. The idea is that they're paying for the same things. And oftentimes EDD will actually file a lien on your case to be repaid for the amounts that they paid you, because state disability insurance isn't there to pay for industrial claims. It's really there for non-industrial things. If I were to have cancer and not have a disability policy, I could apply for SDI. It has nothing to do with work, but they will pay when a case is denied or the insurance company is not meeting their obligation, in which case they want to be paid back by the insurance company.
Got it. Now, there is a really important thing that gets thrown out there, and it's essentially get up to $7,200 a month for benefits while you're in workers' comp. Can you explain where this number comes from and what this is all about?
Yeah, so it's referring to the max rate of temporary disability that's available to you as an injured worker. Every year, the rate changes, and it's just largely dependent on inflation data. So when we talk about, temporary disability, we typically talk about it as a weekly rate, like $1,500 or $1,700. And every year, the legislature changes that number based on last year's inflation data. So we saw a huge amount of inflation through COVID. Even still now, there's higher than normal inflation. It's calming down, but we saw the effects of inflation on a number of things in our society, and temporary disability is one of those. So the government decided, hey, for injured workers to receive a consistently increasing benefit that keeps up with their earnings, we need to ensure that the benefit gets adjusted every year. And it's based on your date of injury. And then going forward, every year, if you're a max earner, you can get more.
Got it. Okay, so not everyone is entitled to, I'm going to get $7,200 a month just because I'm in workers' comp. It's based on your sole case and obviously how much you're making, et cetera, right?
Yeah, an example would be if it's 2/3 your average weekly wage, let's say your average earnings for the past year were $1,000 a week. That would mean that your temporary disability rate is $667 per week. It's tax-free. The idea is that the 2/3 represents your post-tax earnings.
Mhm.
And so that's why it's calculated that way.
Interesting. Okay. So let's talk about permanent disabilities. Obviously, this is way different than temporary disabilities because the word temporary and permanent are completely different things. So when someone has permanent issues that they're not going to get better, that this is something that they're going to live for the rest of their life with, how does that get paid? How does that come into work for someone who's injured within the system?
Once you've reached maximum medical improvement, MMI, or it used to be called permanent stationary. Really, it's just a term that means you've medically plateaued. The doctor feels like you're not going to necessarily improve from any further medical treatment. It doesn't mean you don't need any additional medical treatment, but think of the medical treatment turning more towards symptom management than it is actually going to make you better. Like you may need ongoing PT, you may need ongoing physical therapy, chiropractic care, you may need medications, epidural injections, things like that. But it's not necessarily going to make you better or improve your function long term. And also at the same time, these cases don't have cutoff points. Naturally, people who have injuries may be affected for their lifetime. In these cases, at least from a court and legislative perspective, can't stay open forever. If cases stayed open forever from the court's perspective, they would be overwhelmed. There's no way to possibly manage all these cases for the entirety of time. So really, the idea of being MMI or PNS were created as artificial cutoff points in workers' comp to say, hey, look, it's not that you're 100% better, but you're as good as it's going to get for now for the next year or so. So this looks like a good point to, close your case, basically. And so the benefit is designed to compensate you for the functional limitations that you have that can't be fixed through medical care. Oftentimes that means that you've had surgery, you've had injections, you had diagnostic studies or whatever. It's good as it's going to get. Nothing's really going to change. So let's say you have, X percentage of disability. When we talk about permanent disability, we really talk about either what we call diagnosis-based estimates, meaning you have this condition or medical treatment, therefore you have this percentage of disability. Like you have a total knee replacement with a good outcome, so you get 20%. Or you have a herniated disc in your spine, so you get X percentage. There's also functional-based disability ratings that are typically based on things like neurological deficits or range of motion issues, things like that. And the doctors give those ratings. Those ratings then get adjusted by things like your age, the type of occupation you were engaged in. The idea being that, not all injuries affect people in the same way. If I'm a lawyer and I get my leg chopped off, as long as my mind's in the right place, I can still do my job. If I'm a police officer or a firefighter, a construction worker, someone with a more physically demanding job, and they lose a leg, that can be catastrophic for them. And so typically you would see the more physical the injury is or the job is, the higher the rating gets adjusted. And same thing for the age. If you're young and have a pretty bad injury, maybe you rehabilitate into the workforce. Whereas if you're 65 and you have a really bad injury, it might be time to retire. And so again, the age makes the rating go up or down, which then obviously all those things get factored into how much the permanent disability is worth to the injured worker.
Yikes. I mean, yeah, this is definitely different for everyone, which is really important to notice that if someone at work got injured as well, let's just say you guys have a similar type of situation going on with your workers' comp case, and they tell you, well, I got this much. Again, it all depends on so many factors as to what the outcome is for everyone. It's not a one size fits all. So it's very important to note. I do see we have a lot of questions coming in. Thank you guys so much for putting them out in the chat. I promise you we're going to get to that pretty soon. But I want to talk about what happens when you're screwed. You're permanent disability has, now you got the leg chopped off, right? Like you got a leg amputated and you were a construction worker or you were a firefighter and you can no longer do that career. What are your options then? What happens next? What does the system help with?
So we used to have something called vocational retraining. That benefit over the years, starting in the late 80s to the 90s, has changed quite a bit now. What it is, it used to be a more substantial benefit designed to help injured workers get back on their feet. And temporary disability in connection with vocational rehabilitation actually used to be paid without a cap, meaning theoretically you could stay on temporary disability forever. Of course, now that's whittled down to next to nothing, 2 years, which for a lot of injuries is not enough. And the vocational retraining benefits have been watered down significantly as well. Now you get $6,000 towards re-education if your employer cannot offer you permanent modified work, which, $6,000, it's okay. It's not going to do much for you in a lot of ways. I know of a lot of like certifications and coursework that's substantially more money than that.
Yeah.
So, there is $6,000 there that's in the form of what we call a supplemental job displacement benefit, but it's not a lot. On top of that, the state of California offers something called the return to work supplement, which is another $5,000 payment that's paid to injured workers who receive the supplemental job displacement benefit and have an injury after January 1st, 2013. So, combined, if you are displaced from your employment long-term, then you're entitled to, a combined $11,000 for vocational stuff. Now, the $6,000 voucher you get from the insurance company is not a cash payment. It's a reimbursement voucher, which means it's limited to reimbursement for things like a laptop, coursework, miscellaneous things that necessarily don't have receipts. So there's various buckets of things that the voucher can be used for reimbursement. So it's not, yours to use as you'd please necessarily in any way. The $5,000 from the state, of course, if you want to drown out your sorrows and go to Vegas for a weekend and spend that $5,000 having fun, you're welcome to do that. There's no limitations on the state paid benefit, but a lot of people put that $5,000 benefit to good use. Sometimes not even towards vocational benefits. They're really just trying to get caught up on bills, take care of their kids, things that got messed up and put kind of on the back burner a little bit because of their injury and financial issues. So,
yeah,
really when you're talking about being displaced from your employment, workers' comp has not been great to the injured workers, and it keeps getting chopped down over the years more and more. So vocational rehabilitation, in a sense, is kind of, I don't want to say on a greater scale, phasing out, but it certainly is a lot less than what it used to be.
Correct. Yeah. Unfortunately, things keep changing in the workers' comp world. Is there anything that you would highly suggest those that are watching the webinar right now to advocate and try to should we go on a strike for this or something? Should we protest?
Yeah, call the legislature, but talk to your congressman. But I will say this, on the vocational rehabilitation front, most people do not want to lose their job.
Yeah.
And a lot of times when we're talking about permanent work restrictions, if your employer is covered by ADA, it's 5 or more employees, they have an obligation to engage in what we call the good faith interactive process, which means when you turn in work restrictions to your employer, permanent work restrictions, they can't simply say, we can't accommodate this by. They have an obligation to have a meeting with you to discuss whether or not they can actually bring you back. A lot of times in bigger companies, they have HR accommodations managers who are literally a standalone position that will meet with you. They'll go over your work restrictions. They'll go over the jobs that you qualify for that are available at the company and determine whether or not they can move you in a position that fits. So if your employer, just say if they're a big employer, you got 20, 30 people there, they have an obligation to try to keep you. They cannot simply say, you have work restrictions, so you need to leave. That is disability discrimination, and it's a standalone lawsuit outside of workers' comp, in addition to potentially a retaliation case within the workers' comp system known as a 132A claim. So, just be very upfront with your employer. Make sure you're giving them your work restrictions. Make sure if you want to keep your job, you voice your concern and your willingness to work in potentially a different position. Ensure they're following the process to determine whether or not they can accommodate you. Otherwise, like I said, it could turn into a wrongful termination and disability discrimination case.
Right. How often do you see those types of claims intertwine with a workers' comp claim, a discrimination case?
Fairly common. I would say more common with smaller employers. When you have a mom and pop shop, it's 3 people, 5 people, 10 people, even sometimes mid-sized companies, 20 people or something, it's not often that they deal with workers' comp specifically. And so they don't necessarily pay attention to the details in the law about reasonable accommodations. Although if you're an employer and you're operating in California, it's not a defense to say that you didn't know or you weren't educated enough about the subject. You have a responsibility as an employer to take care of your employees, and it's on them to do that. And unfortunately, it's pretty common where a lot of people say, my boss just told me, sorry, bye. They didn't even meet with me. They haven't called me in 6 months. They haven't returned my calls. That's really, really common, unfortunately.
Yeah. Okay. So we're going to move on to our next subject, which is essentially, remember, the denials and the delays, which put a timestamp on essentially what happens within your workers' comp case. So there's just a lot of information to dive into, and we highly invite you to join us once a month. These live webinars are hosted live on YouTube. You can register also on our website, pacificworkers.com. But there's a lot of questions that get asked that a lot of people don't even think about because they're probably not on that part of their case, or they just flat out don't have the exact same situation. But a lot of these questions apply to most cases as well. So stick around till the end because we're going to have this live Q&A session where we get to pick Bilal's brain to clarify those doubts and obviously understand and enhance your understanding of the system itself. So we talked about denials and how the system plays with that and delays and how this can essentially make a workers' comp case timeline longer than what it should be. Can you break down what someone should do if they've just flat out been denied, and not necessarily denied medical treatment, but just you got denied, the workers' comp sent you a letter in the mail saying we're not going to be liable for your claim because we don't feel it was work related or there's just not enough evidence? What do you do then?
When we're talking about denials, there's really 3 types of denials. There's legal and medical and factual. Your case will be, if it is denied, it's going to be denied for one of those 3. When you get medical denials, the process is fairly straightforward. You go to a QME evaluator and you challenge your treating physician's opinion regarding the denial. The legal and factual denials are a little more complicated. Those are legal and factual issues are not for a medical doctor to decide. Those are for a judge to decide, which means you have to go to court. When you're talking about legal denials, a lot of the common one we see are misclassification of employees as independent contractors, people who are 1099, paid cash under the table, not paid overtime, things like that, because the employer doesn't want to increase their cost of doing business by securing work comp insurance, or they don't want to pay payroll tax and administer benefits, so they cut corners. When you have stuff like that, or a factual denial where, your boss lies and says you weren't hurt at work, you never reported a claim, things like that. All those issues go to a judge, which means you have to do a trial, which means you need experience in evidence. You need experience in presenting testimony and exhibits. You need to understand the rules of procedure at the court. And so when you have medical issues, is it something you can kind of do on your own? Maybe you could kind of figure it out and not be in a bind. Going to trial in court, it's a whole different ballgame, I think. And, on that front, you certainly should contact a lawyer right away. And even then with QMEs, when you get a QME, which is a Qualified Medical Evaluator, it's the doctor you use to challenge a medical opinion that's unfavorable to you. Mm-hmm. Now, the QMEs are not all created equal. There's QMEs who are more conservative. There's QMEs that are more injured worker oriented. There's QMEs that, I don't know, maybe they're just grumpy. They don't like people. Or there's QME that play favorites. QMEs, treat people differently depending on their backgrounds.
Right.
Quite frankly, their ethnicity, their looks, whether they're male or female. It's unfortunate, but it's a fact that there are people who treat people differently based on their appearance, their name, their age, their sexual preferences.
Crazy.
It's just,
it's true.
It happens, But this is to say there's good QMEs and bad QMEs. If you've never done this before, you don't know who those people are.
Yeah.
And you thinking, hey, it's not so bad. I fill out this form, I get this QME, I go to this medical evaluation. You don't really understand the significance of how much power this particular doctor has over your case, quite frankly, potentially your life and the outcome in the future for you medically and financially. And so if you pick the wrong QME, it can be catastrophic to your case.
Yikes.
And we do get quite a few people who have tried to go on their own and pick QMEs, and they end up with the worst QME possible. Sometimes, we take on those cases. I know some names, and, we've had denied cases with the QME, and I take the case specifically because I know the QME and I hate them, and I want to depose them and cross-examine them and kick their butt. But a lot of times, the QMEs are educated, the orthopedic surgeons are people doing what they're doing for a long time. They know how to write a report. They know what to say to support their opinion. And, I'm not a doctor, I'm a lawyer, although, we do have a lot of experience crossing over medical. A QME can wiggle out of things. They can say things in a way that is very difficult to deal with from a legal side of things, and they can really damage your case. And so, if you have a lawyer or a law firm that's done this before, we know who the QMEs are. We know the best specialties to pick. I'd say it's better to probably go with a lawyer to help you through that process than try to figure it out on your own.
Right. So question for you, does a QME determine if a case is done and over with? Like if they've been MMI'd or permanent and stationary, like that's the end of the case?
Yep. A QME will address things like your disability status, meaning whether or not you're still on temporary disability, you're on work restrictions, whether you're MMI or not. They'll address what the percentage of disability is you have following your injury for permanent disability purposes. They'll help weigh in on what kind of medical treatment you should have or referral to specialists or additional QMEs. They'll also determine flat out whether or not they think your injury is work related or not, which again can be, catastrophic. So they do have a substantial say, probably more so than your treating physician on what happens in your case. Your treating physician, especially they're a doctor, right? They're there to treat you. They do the job of actually providing the care to you. Whereas a QME is just an evaluator. The QMEs won't provide medical treatment to you. They just review the medical records. They do an evaluation, usually a physical evaluation, maybe some diagnostic studies, and they weigh in on things that are involved in your case. And so you don't get to go to a QME and the QME is not going to do, a shoulder replacement for you or give you medication or things like that. So the QME essentially is just kind of think of it as like a second opinion in some sorts.
Got it. And that's good to clarify, because I feel like a lot of people will go to the QME and be like, well, that doctor didn't even do anything to me. He didn't even check me. And it's like, they're essentially checking you, but through the records of what your previous doctor, or you're not your previous, but your primary doctor is stating and what they're physically seeing versus, what the insurance is claiming. So they're putting everyone's perspective into their expertise and coming up with something.
Yeah.
Okay, that's good to know. All right, well, here comes the fun part about this webinar. If you've been watching and sticking with us, thank you so much. We appreciate it. I see you guys. We do have a pocket guide book written by Bilal himself. This book is completely free. Anybody can download it. There's a lot of information that was thrown into this book. So tell me a little bit about what someone will find in this book, Bilal, and why you guys decided to publish it.
So this book essentially is a brief overview. I say brief because, we can't possibly cover everything. I've got, I don't know how many years, since 2008, I've been involved in workers' compensation. So, quite a while now of knowledge and experience. You're not going to get that from reading this book, but we've taken the most we can and we've broken it down to be as simple as possible, to give you as much coverage as we can as a basic overview of the things that you'll encounter in workers' compensation at a very high level. So for someone who's not experienced in workers' compensation, this is about as simple as it gets to get a big understanding of what the system is, how it works, what's available to you, common core terms and definitions for things that you may see in workers' compensation that wouldn't otherwise be explained to you. So it's a good brief outline of the system in general.
Got it. So for those of you that want to get the book and you jumped on Pacific Workers' YouTube channel, We do have it online on our website, pacificworkers.com. So you guys can go to the website, click on the menu, and it's I believe it's in the About Us section. That's where you can download it. And you can also check if you've registered on this webinar through our email, your emails. They're going to send you an email that's going to give you this link and tell you to download this book. It's a very important book. I definitely think it'll teach you a lot of things also that we didn't thoroughly cover in this webinar. So you're definitely going to want to read it. It's not big. It's not a thick book. I promise you. It's super simple. It's written in plain English so that you truly understand it. And it doesn't have like big, ginormous words. It's essentially meant for you to truly have a starting point for your case. So I hope you guys get the opportunity to join this part of the webinar and download the book. I promise you, you won't have anything to lose and so much more to gain from it. So Bilal, without further ado, I think we are ready to go into the Q&As. We have an extensive list of questions.
Let's do it.
Yep. So I am going to start with what typically delays or makes a case drag out?
Multi-vlogger, I see you. I do have crazy hair, and I did have a crazy last night. I am a new dad, so for all the dads and moms out there, and you guys know what it's like to have kids, it's a crazy night, not out partying.
No, not partying. So Bilal is just coming back. Actually, he's essentially in paternity leave and decided to do this webinar with us. So he sneaked out of paternity leave to come here and be with all of us. So we appreciate you and your wild hair.
Of course. But, typically, to answer your question, multi-blogger, the things we see that are causing delays and make a case drag out, it's usually either an issue with the insurance company not providing authorization or benefits for something, or potentially litigation delays. An example of this would be, let's say you're supposed to get temporary disability and a check goes missing. We may try to call the insurance adjuster for 3 weeks. We'll write them nasty letters. We'll send them emails. We'll bug the crap out of them. And if all else fails, we'll request a hearing. The type of hearing we'd request is an expedited hearing, which is the fastest calendared hearing that we can get, meaning that's as fast as it goes to get a court date, which is usually 30 days out. So just an example, if we have to wait till a court date just to get you your temporary disability, that could be a month or more of you waiting. Additionally, the same thing for treatment authorization. Or let's say the defense is not happy with a QME report you got. Let's say you got an awesome QME report, says you have a super high disability rating. Everything's awesome. You're very happy with it. We're very happy with it. We want to push your case to trial to get that award for you, get that disability rating locked in. The insurance company may object to the QME report. They may say, we want the QME to review these additional records, or we want to take this QME's deposition. They set the deposition out 3 months. They say they need to get the records first. The supplemental report could take 60 plus days to get, so you could be waiting months and months and months just to get that report or just to have the defense do what they need to do with the QME. And then you still need to wait for your court date. You still need to wait for your trial. So, a lot of times, depending on the pace of litigation, whether or not the insurance company is doing their job to pay your benefits, authorized medical care and such, there's a lot of these like 30-day, 60-day, 90-day periods of delay that are baked into the case frequently for various issues. So a case that, maybe should theoretically be, 180 days max for medical treatment, recovery, post-operative care and everything, MMI, could drag out 2 years because of all the delays, and it's not one delay, it's multiple delays for every little thing. And it's really common in these workers' compensation cases. So, there's a variety of issues that get baked in that are problematic, but I would say it really boils down to, are things getting provided to you on time? Is the insurance company legally doing what they need to do? And how much pushback, how litigious are the insurance adjusters on this particular case? And those are really the large reasons we find delays.
Okay. We've actually recorded a podcast specifically on delays. So I would highly suggest if you go onto YouTube and Work Comp Talk podcast, You can find all of that information as well on there. What about the next question? It says, hi, I work in a hospital. I recently found out while I was attacked by a patient who was attempting to kill another patient that, the dispatcher who has priority 1 alarm to notify everyone, all security officers, of an emergency was happening. The button was pushed. Unfortunately, it crashed the system. Not everyone was notified while this person was in the room fighting with the patient. A lot happened. And this information you guys would need, since you guys are, is this information you guys would need since you guys are already helping me with the orthopedic office trying to treat my leg since I have a torn ligament, making it difficult to walk. Does this type of information apply? Should we share everything? And that's from Paul.
Thanks for the question, Paul. Just based on this, it doesn't sound like it. To go off topic for a little bit, there's something called serious and willful claims in workers' compensation. As I stated in the beginning, workers' compensation was a carve out for negligence cases. The whole idea is that you do not have to provide or prove fault in order to get benefits. It's just deemed that, hey, something happened to you at work, whether or not it was caused by negligence, you still get the benefits. There's yet another carve out within workers' compensation to say, well, maybe we just thought about normal negligence or just stupid things happening or just freak accidents. But what happens when the employer does something so egregious, so criminally negligent that we should hold the employer liable personally above and beyond workers' compensation insurance for your injury? And those that are called serious and willful claims. So if you can prove that your employer engaged in serious and willful misconduct that led to your injury, you can collect additional benefits in workers' compensation. Now, serious and willful claims are largely dependent on whether or not the employer knew of the dangerous condition, knew of the likelihood of injury, and did or didn't do something which led to your injury. In this particular case, if the alarm system was not necessarily working in order, I don't know, that doesn't sound like it would be something above and beyond that would really lead to that level of criminal negligence. When we're talking about those dangerous conditions, we're talking about things like, a defective tool where the employee told the employer, I'm not going to use that tool, it's defective. And the employer said, too bad, so sad, go use it. And, they get injured. That would be an example of serious and willful misconduct. So, the facts and background of your case don't sound like they would necessarily help or hurt you at all, other than the fact that you are entitled to workers' compensation because you had an on-the-job injury.
Yeah. Okay, Paul, we have a podcast on that subject as well. Carolyn wants to know, I need cortisol shot and therapy. I've been off work 3 months and I work for Trader Joe's as a customer graduation. Oh, that's a really, really long one. So I guess the question would be, I need cortisol shot and therapy. I've been off work 3.5 months. I work for Trader Joe's. So what does it look like when someone is getting cortisol shots? Is this covered by I'm not sure I understand the question exactly. So let's assume that she's asking, this is her situation. What's next?
Sure. A lot of doctors will say that you can be temporarily totally disabled for periods of time following medical treatment, certainly certain procedures. A prime example of this, a lot of doctors will say that you're temporarily totally disabled, at least for a few weeks following an epidural steroid injection. You could have work restrictions that change depending on the type of treatment you're having, whether it's surgeries or otherwise. You can also come in and out of MMI status. We've seen it a lot where a doctor will say that you've reached maximum medical improvement, and then a surgery is then authorized by utilization review, which then takes you back out of MMI status and could mean that you're entitled to temporary total disability again. So your disability status can fluctuate, and the type of disability status within temporary disability, whether it's work restrictions or completely off of work, can change as well.
Yeah. Okay, well, thank you for answering that, Bilal. Now we have Jody. She's been on TTD for 3 months after bicep surgery. She's still in pain. The nurse case manager told her that if she can't do her previous job, there's no job for her. What can she do?
That's really weird that a nurse case manager would say that. A nurse case manager, their primary role is to facilitate the claim in medical care. I can say from experience, not all nurse case managers are created equal. There are some that are really great. They really help get people the care they need. They're a liaison for the insurance company and the doctor's office to ensure things are getting done on time. There's
Mhm.
other nurse case managers that are hounding the doctor. Why haven't you said that this person is done treating yet? Why haven't you said they can go back to work? When are you going to be done? And really pushing them to, expedite this person's care so that they can go back to work. Whether or not you can go back to work is a decision for your employer and no one else. An insurance adjuster may have communication with you about that process, but whether or not you can go back to work is something that should come from your employer, not a nurse case manager. To the extent that there are jobs available to you that fit within your work restrictions, that an employer, like I said, they have an obligation to determine whether or not they can accommodate you. To the extent you have work restrictions that an employer can't legitimately accommodate, then technically you can be let go. In which case, if you are let go, you're not getting permanent modified work, which means you're entitled to the voucher as well as the supplemental job displacement benefit and the return to work supplement from the insurance company in the state of California. So, you get those two benefits, but unfortunately, it's not enough to replace a career. And we see this all too often where a lot of people have good paying jobs. They dedicated, 20, 30 years to them. And something, dumb like a thumb injury, not to belittle thumb injuries, but, relatively minor injuries can really displace someone's entire career. And the compensation you get is certainly nowhere near, accounting for a lifetime of work and dedication. So, it's one of the areas where workers' compensation really falls short and underdelivers for injured workers because a lot of people have injuries and they're forced out of their employment.
Right.
And the benefit they get is rather small. But, again, I would check with your employer. Don't just hear it from the nurse case manager. Reach out to your employer. If they're big enough, their HR department, they should be able to talk you through where you're at in the process. And they should be able to give you guidance about whether or not they can accommodate your work restrictions.
Yeah. Okay, great. Now we have Lourdes, who's had severe tendon and elbow pain in her left arm. She has been seeking legal help and she had an MRI and a PT, but needs some serious attention to her left arm. How can she go see a specialist? She fears her job is feeling like she's just prolonging her healing, but she's in pain every day and hasn't been healed. How can she improve this situation in the sense of, does she communicate with the company and tell them, like, people are in this situation constantly?
Yeah. So, throughout the process of workers' compensation, it's always important to keep in contact with your employer. To the extent you have work restrictions, you should always be discussing with your employer whether or not those are things that they can accommodate. From the employer's perspective, they have to be careful because they're concerned if they're doing things right, that they do not bring you back into a position that is going to exceed your work restrictions. They can't set you up for failure. An example of this would be, if they have a position that requires 5 hours of standing a day and you have a work restriction that you can only stand 3 hours. You go back to this position because they feel bad. They want to bring you back to work. They know you want to work. And then it makes the injury worse, or you're not performing the job well. And so ultimately they have to let you go. That could lead to a disability discrimination, again, ADA access lawsuit. So they have to be careful about putting you in a position where you're going to do things you're not capable of, and not doing them great. And at the same time, they also have to weigh that against whether or not they can actually accommodate your work restrictions and engage in the interactive process to find something that they do have. And, not necessarily creating a job out of thin air that would be a stretch for them financially. It's all about whether or not it's reasonable. So, they're balancing their ability to accommodate you with your medical needs and ability to work. And so that's always a delicate balance, and if they're a good employer, they should really try to do that for you.
Right.
As long as you're off of work and your work restrictions are current, you have up to 2 years potentially of temporary total disability. And to the extent possible that that's financially feasible for you, I know it's a slow process, but, I'd give it time to see whether or not you can actually get care you need to improve your condition.
Right.
Workers' comp is a really slow process. I've got some cases they've been going on 8 to 10 years. I've got other cases that get resolved in 6 months, and everything in between. And it really just depends on medically what's going on with you, long term after the care, how much you're going to improve, and whether or not they can accommodate work restrictions that will allow you to be successful for 4 to 6 more years of work.
Well, what if the work restrictions are not going by what she's feeling? Say she really is in pain and the work doctor told her, yeah, you can go back to work, but she's still in severe pain. What are her options then?
You can seek a second opinion. You can go to a QME. There's a really weird issue in workers' comp where you have work restrictions insofar as your right to collect benefits, temporary disability, permanent disability, the voucher, return to work supplement, things like that. But then you also have the ADA side, and the idea that they can't discriminate against you, they can't retaliate against you, but also, they can't have you back if you have certain work restrictions, because just as much as it sounds great that they'd want to have you back, if you're comfortable doing things in excess of the work restrictions, they're also worried on their end about you claiming that they're asking you to work beyond your work restrictions. Not that it's voluntary, but that they're forcing it. And so they're afraid on the other side that you're going to say that, they weren't, necessarily asking you to do all this stuff you wanted to, but you're going to tell the court or a jury that they forced you to do this stuff, that you told them your work restrictions. So they don't want to necessarily bring you back if you're going to, do things in excess of your work restrictions. So, as an interim solution, I usually tell people, look, if you're not happy with the work restrictions, go to the ER, get an updated note, get something more up to date than the last work restriction that takes you off of work or changes your work restrictions. You can change your primary treating physician to someone else if you feel like the doctor is not listening to you and not giving you the work restrictions you feel like you need. You may get different work restrictions from the QME as well. So there's ways you can challenge your doctor's opinion. But on the employer side, just as much as it's important to stay on top of things in your workers' comp case, it's important to stay on top of your employment status and have regular check-ins with your employer. Make sure they're getting your work restrictions, constantly asking them if their ability to accommodate those work restrictions has changed or not, or there's other positions. So, I know it feels like it's slow and there's a long time, for not a lot to happen, but, you just got to really be patient. And at the end of the day, it's really about your permanent work restrictions. And once you've reached that MMI status, whether or not your employer can accommodate you at that point.
Yeah, it's a tricky situation to be in for sure. Thank you for that comment. Francisco is asking, first he said, thank you for your time. With advances in AI and automations, is there a danger that workers' comp decisions become even more impersonal and unfair to the future? I'm sure you'll love to answer that one.
Yeah, no, it's fascinating. We already see it being in the business. One of the most common issues I see right now with AI, and I don't know how often it's happening, at least what I've seen, is medical facilities, doctors, and law firms, I'm sure adjusters, using AI to summarize medical records. It's something really common that I see. I might have someone's medical records that are 3,000 pages of Kaiser records. And is someone going to go through 3,000 pages of Kaiser records looking for every time a specific medical condition is, listed? No, they're going to use AI to summarize it. They're going to use AI to search it. They're not going to do their due diligence. Oftentimes, AI can conflate things. It can hallucinate and say things that aren't necessarily true. And so to the extent I see record summaries, I do see errors. I do see issues. And so to the extent doctors or other professionals are relying on AI to summarize and discuss patients' medical records, I see that as already a use case and also a potential problem. Outside of that, the court system is not going to use AI, at least as of now. I don't see a huge potential issue with that long term. Really right now, the main source of AI that's used in the legal side of things is for case law research and things like that, which I'm sure you guys have seen. There was a lawyer that got in trouble in court because he wrote his brief using AI and made up a case that didn't actually exist. So, there are some use cases, although it's pretty archaic, as a court system. So I don't see any major changes in AI coming to fruition right now. You do see it on the risk management side, on insurance company side. They use AI to calculate, potential case values, to look at the potential liability they may have. They use it to make decisions about liability. So there are a lot of use cases right now, I think, privately, but not as a system. So I don't really think that necessarily will make anything more unfair for the injured workers, at least for the time being. But there's also tools that we can use for the injured workers. So it cuts both ways. So, the faster that we can use these tools to do good things for people, the better off everyone will be. So I think there's a potential good use case and a bad use case for technology as it changes.
Yeah, for sure.
I will say this real quick, if I can add on to that. An example of how slow the court system is, it wasn't until COVID where depositions basically started happening via video call. Before every single deposition used to be in office. All the court hearings used to be in court. Now we've got teleconferencing, we've got video depositions, but it took a pretty big catastrophe to make any major moves. So it's just an example of how slow things move. I don't think we're going to see a huge technological change anytime soon for workers' compensation as a whole for the time being.
Yeah. Okay. Well, that's a great example. We have another question. Should I disclose to my new employer of an injury I had at my previous job?
So this comes up a lot. People think that a workers' compensation case becomes public record and that anyone can look it up and find your injury and find all your medical and stuff. That's partly true. If you have a workers' compensation case filed with the court, you can search a person's name and date of birth and see that they had a workers' compensation case. You can't see the details of it. Okay, so medical records are private. Obviously, it's protected by HIPAA. The details of your claim are private. You can see that there was an injury. You can see the date of injury. You can see who the employer was. That information is there. But whether or not you choose to disclose that is 100% up to you. Disclosure is not mandatory. It's an option. And I know a lot of people have this issue because they're concerned if they disclose that they've had injuries before, that the employer will not hire them, which may or may not be true. It depends on the employer. But I get that concern. It's a very valid concern. The only thing you have to worry about is whether or not you have work restrictions. The idea being that if you have work restrictions that you did not disclose at the time you're applying for a job, and it turns out they're not accommodating your work restrictions, or you're terminated because you couldn't do the job, you obviously can't turn around and claim wrongful termination. You can't claim that they were discriminating against you. So, to the extent that you need to disclose work restrictions because you need to, because you can't do the job without those work restrictions, and obviously you have to disclose that. But that's only disclosing what your limitations are and what accommodations you need. And because of HIPAA, you're not required to disclose, in detail about your medical conditions or how those medical conditions happen, whether or not work related or otherwise. So, it's up to you. It's a judgment call. I have a lot of people that don't disclose prior work injuries, and that's fine.
Got it. Okay, we have 3 more questions we're going to be taking. I have Gracie's on here, which says, what is an average or decent permanent disability percentage?
None. I say that because permanent disability hasn't changed since 2013. It's $290 a week is the max rate. So everyone who's been around here for longer than 2013 knows that prices in 2013 are not what they are today, from food to gas, rent, everything. So, in my mind, there's no permanent disability percentage that is good enough to compensate people for their injuries, regardless of what that percentage is. So I use that as a baseline. But I will say whether or not it's a good disability percentage depends on the type of injury that someone's having. Permanent disability percentages are not attached to your ability or inability to do your job. An example I give, I used to represent professional athletes for workers' compensation. And I had a lineman who had a substantial thumb injury. This is why I joked about the thumb injury earlier, is because it's a thumb injury. This guy is a professional athlete. He is in peak physical fitness. He is a beast. He played for the NFL. And he can no longer be a professional football player because of his thumb, because as a lineman, he has to do a 3-point stance and he has to support his body weight on his hand, and he could not do that anymore. And so that affected his gameplay.
Damn.
And so, what did workers' comp pay for a thumb injury? Nothing. I don't know if thumb injury is relatively, low value, I guess, in terms of workers' compensation. But, you may have someone who's got a multi-million-dollar football career who gets a 5% permanent disability rating that's worth $7,000, and now they can't play professional football anymore. And I use that example for athletes, but it happens to everyone. It could happen to teachers. It could happen to construction workers, cops, firefighters, nurses. It doesn't matter. You could have a small injury that ultimately displaces your career, and the percentage disability you get is wholly inadequate. And so, when we're thinking about disability percentages and whether they're good or not, we're kind of thinking of them just insofar as, how is this injury impacting this person, and is it a good value in that sense? And sometimes it doesn't matter what we want. It's just never going to be good enough. But each disability percentage is different. And I think when I look and say, this is a good disability percentage, I'm looking at the rating system that the doctors use, the AMA guides, and I'm asking myself, is this the best possible rating this doctor could give for this condition within the limitations that they are given under the law? And if the answer to that is yes, I'm a happy camper. My client may not be, and for all the reasons I've explained just now. But really, I'm just making sure the doctor is doing what they can to give the best possible rating with the rating system we have.
Mm-hmm. It's a lot. It's a lot. Okay. Thank you for answering that one. So Michael has a question. He says, if there's 104 weeks of potential temp disability, but the adjuster denies what your assigned doctor suggests, what happens? What if the adjuster continues to roadblock and make approvals and access to your treatment and making things difficult?
So this depends. I assume you mean when the adjuster denies what the doctor suggests. I'm assuming you're meaning utilization review, which means utilization review is denied the care. And so if you're not getting the care you need, what's the point of being off of work? Or what happens if, you're not necessarily getting temporary disability because the temporary disability is associated with the medical treatment. For example, you would be temporarily totally disabled if you were to get a surgery, but the surgery is being denied by utilization review. You have the IMR process, which, like I said earlier, is terrible, but that's the process you have. If the utilization review decision is procedurally appropriate, meaning it was served on you timely, it was sent to the doctor, everything, the boxes are all checked, basically, it's a valid decision. IMR is your only recourse. And if IMR upholds the denial, you're stuck. That stands for 12 months. If you don't have a lawyer, you got the utilization review decision, I would encourage you to take the utilization review decision and discuss it with the doctor that requested the treatment. Ensure that the doctor got it for one. If they did, have a discussion about whether there's things that the doctor can do to create a material change in circumstance. So if whatever the treatment is, the MRI example, you want surgery, utilization review said no surgery because you didn't have an MRI. Go to your doctor and see if they can request authorization for the MRI. Go back and repeat the steps in a different way to try and establish a change in circumstance. So that may give you another shot at potentially getting around utilization review.
Interesting.
Alternatively, if your case is stalled, you're not getting the care you need, potentially settlement is an option for you as well. There's something called a compromise and release where essentially they buy out the value of your case, including medical care. It's usually not great, to be 100% honest, because your medical care is almost always worth more than they're willing to pay. But if you have enough money to then go either with a private insurance plan that you have or deal with things out of pocket, potentially going and taking the medical care into your own hands to accelerate your recovery is in your best interest. There's quite a few ways to deal with it. And ultimately, the strategy is just largely dependent on where you're at medically, financially, whether or not, you can keep hanging on basically and waiting. But really, it also boils down to whether or not the insurance adjuster is doing things properly. If the denials are legally appropriate, you're kind of stuck. If they're not, then, you may need to request a court date and have a judge address whatever the issue is. But an alternative to income, to answer your question too, to this other person, I just want to talk about this too, is really state disability. So you can apply for state disability through EDD if you're not receiving temporary disability benefits as well. And depending on how substantial your injury is, you may consider applying for Social Security disability as well. That can have some pretty significant impacts on your workers' comp case. So I wouldn't do that without necessarily talking to a lawyer first.
Got it. Chris wants to know, he wants to know if he can go ahead and put in for his retirement while this workers' comp case is going on. His short-term disability is coming to an end. He is in retirement age, so he wants to make sure he's retiring and not going to interfere with the case.
So when you retire from work, you're voluntarily removing yourself from the workforce. So if you're receiving temporary disability, for example, your temporary disability could potentially stop because you're not able to work, and so you're not displaced from your employment if you're not actually going to go back, right? So I know, Chris, in your example, it looks like you've got a short-term disability policy, which would be something different. But obviously, if you're receiving temporary disability and you're thinking about retiring, thinking that the temporary disability would continue into retirement, that may not be the case, and you should be cognizant of that. Generally speaking, if you're retiring too, that may eliminate your ability to collect the voucher if you're removing yourself from the workforce, thereby eliminating the employer's need to offer you permanent modified work. But largely, we see people who retire quite frequently. A lot of times it's kind of a forced retirement. If you're a public employee, there's CalPERS, which people have the option for either service retirement or disability retirement. And so we see a lot of firefighters, police officers opt for pursuing a disability retirement in connection with their workers' compensation injury. But it's, if you're not really concerned about the temporary disability and you're ready to retire, retiring won't necessarily impact your workers' comp case at all. It doesn't affect your permanent disability rating. It doesn't affect your right to future medical care. So as a whole, it can be a good decision and it could be the right time. And at times it does not impact the workers' compensation case at all. Other times, like I said, it may impact some benefits, but not long-term as a whole. So I would say, Chris, to the extent you're thinking about retirement, just based on what you're telling me, doesn't sound like it's going to be an issue, but, I would have a longer conversation specifically about what's going on in your case, what your goals are to determine if it's the right time or not. Sounds like it might be though. So.
Right. All right. Well, I'm going to wrap up the questions right there, but I do want to invite everyone, if you still have questions, go ahead and keep dropping them in the comments. We do reach out to you as well. And if you're still very lost within the system, I highly encourage you to get a free consultation, talk to the team, let them know your situation, and that way they can, just like Bilal did with certain of these cases, guide you as to what options you have without any strings attached, not trying to be like, well, you should let us represent you. It's ultimately to guide you on your next moves. And then if you like what you hear and that person is telling you things that you're not going to be able to take care of your own, then you can decide whether you seek legal counsel or not. Again, visit pacificworkers.com. You can chat with us. You can send us a text message if you are at work and you don't want to be on the phone. You can call us and definitely get those answers to your questions. I don't know what else to say besides don't let the system cheat you out. Is there anything else you want to talk about, Bilal, before we close with this webinar?
Oh, just hang in there, guys. It's a really crappy process. It's the best we have, unfortunately. We still have something, but it's one of those systems where you fight for every inch. And I know it can be frustrating and it can take a long time, but it's just the hand we're given. It's just the system that we have to work in and the rules that we have to play by. But don't let that defeat you, and keep up your hope and keep fighting.
Yeah, for sure. Well, thank you so much, Bilal, for leaving your baby behind for a little bit and joining us. Once again, visit pacificworkers.com. We are here to help you. The entire team is available 24/7. They can help you answer your questions and help you kind of think of a roadmap. And whether you want to do that road with us holding your hand the whole way or not, you're going to be able to have this strategy and this talk with our team to let you know what are the options that you have. Again, we'll catch you guys next month. If you're watching this on YouTube, make sure you subscribe to our channel and hit the bell notification so you get notified when we upload new content, which is constantly. Follow us on our Work Comp Talk podcast. We have episodes weekly. We talk about the most important parts of workers' comp. We share a lot of secrets through there as well. And without further ado, we'll see you guys next month. Thanks, everybody, for joining us.